petition opposing Disney's trademark on the widely popular phrase Hakuna Matata has reached nearly 2,000 signatures. Does Disney hold a valid trademark in the Swahili phrase? Find out on episode 2 of Reels and Gavels.
Disney is making news today connected to its blockbuster animated movie The Lion King.
Disney has robbed the Swahili-speaking nations of the term Hakuna Matata.
We'll talk about what Disney has done, which is to trademark the Swahili phrase Hakuna Matata.
Welcome to the second episode of Reels and Gavels, the show where one unqualified law student breaks down the latest issues of law and entertainment. With that said, nothing I say should be taken as legal advice. At most, you may consider it semi-learned speculation. On this episode, I want to tackle the recent firestorm that has swept across the online community. I'm speaking of the international media outrage against Disney's trademark of the phrase Hakuna Matata, which means no worries in Swahili. Please feel free to apply your joke of choice regarding the irony of the situation here. The controversy in question began following the publishing of an article in the Kenyan newspaper Business Daily, which called out Disney's trademark of the phrase as the latest example of a disquieting trend of Western corporations misappropriating East African culture and heritage for their own profits. The article led to a petition in opposition to the trademark and has garnered the attention and support of the entire online community. The petition calls for Disney to abandon its trademark, and in the larger context, it aims to reject any corporations or individuals looking to trademark languages, terms, or phrases they themselves did not invent. This would be a troubling proposition for trademark law, as in many cases, trademark is based on a new unique use of common phrases, words, or symbols, and not invention of entirely new terms. Think of something like "I'm loving it" or "Can you hear me now?" Largely meaningless phrases which have acquired a secondary meaning through the success of McDonald's and Verizon. The trademark in question stems, of course, from the popular film The Lion King and has gained global popularity through music, soundtracks, Broadway plays, and endless merchandising.
Merchandising? Merchandising? What's that? Merchandising. Come, I'll show you.
The phrase itself, however, has been a popular saying in Africa for many years, gaining mass popularity roughly a decade prior to The Lion King, when the Kenyan band Them Mushrooms released the song Jambo Bawana.
Wakaribishwa Kenya yetu, Hakuna Matata.
Hakuna Matata translates to "no worries" and would be a difficult phrase to trademark in the USA under the English translation, but it still wouldn't be an impossible task. After all, Paris Hilton trademarked the phrase "that's hot."
That's hot. That's hot. That's hot. That's hot. That's hot. That's hot.
So let's break down whether Disney can trademark something so common to East African culture. Does it mean we can't say the phrase to one another without violating trademark and facing lawsuits? Will Kenyan companies that sell Hakuna Matata t-shirts face lawsuits? Find out. Stay tuned. Now, to begin, there is a big misconception going on online that Disney is either planning to trademark the phrase or has only done so in recent months. This is completely false. Disney applied for the Hakuna Matata trademark in 1994 with the release of the first Lion King animated feature. For one reason or another, the trademark was not actually granted or registered until 2003. Now, the trademark went unchallenged to my knowledge, and in 2008, after 5 years of continuous use, the mark became an uncontestable mark under Section 15 of the Trademark Act. This means the mark is incontestable and the registration is conclusive evidence of the validity of the registered mark and its registration. In other words, this essentially means Disney is almost guaranteed to win against any challenge of its right to the mark. There are, however, a few exceptions. Now, Disney could still lose their trademark due to abandonment, which can be presumed after 3 years of non-use, or due to the phrase becoming generic through genericide. Sounds intense, right? Genericide means that Hakuna Matata becomes a generic name describing the goods or services with which it is associated. This might be kind of unlikely in this case unless we begin to call t-shirts Hakuna Matatas. So, for example, do you associate thermos, aspirin, zipper, escalator with any particular company? I didn't think so. All of these names used to be protected trademarks until the public perception changed and the names became common use descriptions of the products. Now this brings us to the next misconception. In all likelihood, the people's ability to use the phrase Hakuna Matata in African countries for the purpose of selling items such as t-shirts shouldn't be affected. Hakuna Matata may be a commonly used phrase in Africa, and it's unlikely to be distinctive enough to be associated with Disney in that country, especially with its common use on things like t-shirts. It is also likely that Disney would not be the first to use the phrase on t-shirts in Africa, and may not be able to acquire a trademark, as trademarks are granted to the first company to commercially use a given mark, at least in most jurisdictions. Some jurisdictions do consider the first to file the trademark registration as being the person who holds the trademark. In either case, this leads to a bit of a paradox, as the petition against Disney may be causing more damage than good in terms of the law. How so? The petition is arguably raising awareness in Africa that Hakuna Matata is a trademark owned by Disney and not just a common saying. This is essentially free advertising for Disney, which may help its trademark acquire secondary meaning in Africa. Imagine if I set out to register a trademark for the phrase, "Good morning" for my YouTube channel. Sounds ridiculous, I know. But what if someone started opposing my idea, and a petition went around trying to stop me, followed by countless news stories that said my trademark of good morning isn't fair? I'd be thrilled as a trademark holder, because whether the public likes it or not, it's the awareness of the mark's use as an identifier of my channel that really matters, at least in terms of trademark law. Ethical and PR issues being another story entirely. So if Disney is unlikely to obtain a trademark for Hakuna Matata in Africa, does this mean people in the United States can't use the phrase in videos or conversations? Not really. Trademark is used to identify the source of goods, not to restrict expression or ideas. As long as Hakuna Matata isn't being used in commerce, it shouldn't be considered trademark infringement to sing the Hakuna Matata song with friends. Now, copyright is of course another story. The purpose of Disney's trademark is the same as the Nike swoosh or Adidas 3 stripes. It tells the general consumer that seeing Hakuna Matata on a t-shirt probably means the shirt is made or licensed by Disney. What's more, Disney has only registered a trademark specifically for t-shirts. So can you make Hakuna Matata backpacks, sailboats, vitamins, baby strollers? Well, yes and no. Even unregistered trademarks can get protection. So even if Disney did not have a federally registered trademark, now that's what the petition is asking for them to drop essentially, it could still sue people who use the phrase on t-shirts, although with slightly less results, or because they would receive slightly less protection for an unregistered mark. Now this is why Disney can still oppose trademarks of items such as backpacks or baby strollers by other companies or individuals. The contested trademarks, however, still have to be similar to items that are associated with Disney. For example, non-affiliated Hakuna Matata vitamins or sailboats might not be something Disney could attack for trademark infringement, because Disney does not sell things of that nature. Neither does it put the Hakuna Matata mark on such items. At least not yet. Backpacks and strollers are another story, as Disney does license its unregistered mark out for those products. In fact, there is a pending trademark filed by a Chinese baby stroller business owner that is currently being opposed by Disney because it would infringe on their unregistered trademark. Some of the arguments against the mark which are being made by Disney include that there would be a likelihood of confusion. If this Chinese owner was to put Hakuna Matata on their baby carriages and things of that nature, consumers might be confused, believing that that mark belongs to Disney, and they would buy the product because they believe it's a Disney product. The second argument being made by Disney is that the Chinese stroller maker is diluting the distinctive quality of the Hakuna Matata mark. Dilution essentially occurs when a famous mark is being infringed on and the public perception is being weakened, even if it is for a completely different product. For example, if you were to have a Coca-Cola furniture company, although that's not trademark infringement of the Coca-Cola mark, which applies to soft drinks, it is dilution potentially because it is weakening the brand. The Coca-Cola brand no longer holds the same meaning. It is no longer, you might no longer associate Coca-Cola with the soft drink because of the furniture company. It is important to note unregistered trademarks do not include remedies such as attorney's fees or damages, but result in injunctions which may prevent you from further infringements. In the case of the mark being opposed by the Chinese company, they will simply receive a denial of their trademark application. So in conclusion, we can all say Hakuna Matata in conversation without Disney police coming after us, and businesses in Africa may even be able to sell Hakuna Matata t-shirts where the phrase is a common saying not associated with Disney. The main consideration with trademark law is whether use of a term is likely to cause confusion among consumers as to the origin of the product. In other words, the more we talk about Disney's trademark, the more we strengthen the association between the phrase Hakuna Matata and Disney, leading to a higher likelihood of confusion. Another consideration is that even if Disney was to abandon its trademark, it could still pursue lawsuits for the unauthorized use of Hakuna Matata under copyright law, as a phrase is the title of a song and a distinctively famous part of the Lion King film. Whether Disney will actually pursue such lawsuits over the use of a misappropriated phrase from the Swahili language is another question, and perhaps a petition arguing against such practice can send an effective message to Disney. Well, that's it for episode 2 of Reels and Gavels. Check out episode 1, it's about Fortnite and another issue of cultural misappropriation. Let me know if I got anything wrong, it's how we all learn. Leave a comment, debate below, drop a like, subscribe, oppose my trademark, and check out the next video on Reels and Gavels.